Hey everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York, and in this video I'm going to go over some practical problems that you might encounter when you try to apply community property law in the real world. In the real world here is going to be basically a California divorce case. So a while back I recorded a video that basically introduces the idea, the term, the concept of separate property and community property. I'm going to go ahead and link that video. I think it pops up over here if I'm not mistaken. But the basic idea there is that community property, it's defined in California Family Code section 760. Basically includes all the stuff that you acquire during the marriage. Everything else that you acquire from before, everything else that you acquire after, generally is going to be separate property. That's Family Code section 770 in California. There are some exceptions to that also, so that's not precise what I just described, but that's a good rule of thumb to kind of keep in mind. Stuff that you acquire during the marriage, stuff that you acquire before or after. So the concept itself is not terribly complicated, I think, but when you actually try to apply community property law in the real world, again, in a California divorce, you might run into some problems. The application sometimes can be more difficult than the concept itself. So I'm going to go ahead and go over some of the problems that are pretty common, I think. So number one is going to be the existence of a hybrid asset. So a hybrid asset is going to be something that is not 100% community or 100% separate property. Like it doesn't neatly fall into either or, like it's basically some percentage separate, some percentage community. A really common reason why this happens is basically something that you might buy, for instance, before the marriage, you pay for a little bit, but then you pay for it during the marriage as well. So the thing is, you purchase something, you finance it over time. During that time that you're financing it or that you're paying for it, a marriage occurs, for instance. So a really common kind of scenario would be, let's say that one person, like one of the spouses, when they're single, they buy a house, themselves. So they make a down payment. They pay for the mortgage, themselves for say 5 years or so. And then after year 5, they get married, and then after that, they pay for the mortgages, except now it's jointly paid. Like, the husband and the wife or the two spouses pay for the mortgage together, whereas before it was just the husband paying or just the wife paying or something. So, in a situation like that, the house is going to be a hybrid asset. Some percentage is going to be separate, some percentage is going to be community. If you're interested in the precise formulas for that, there are formulas. I'm not going to go over them here because the formulas can get really involved, but they consider things rather, factors such as the purchase price of the house, the appreciation of the house, the equity in the house, the date of marriage, the length of the marriage, etc. Like all that stuff will get fed into the formula to actually compute how much the split actually is, like how much is separate, how much is community. Again, I'm not going to go into the formulas precisely, but there are formulas that actually will compute values like that. So that's number one. The existence of a hybrid asset can make applying community property law in the real world more complicated than the concept itself. Number two, as you can probably tell from the very beginning of this video, the date of acquisition is really important when it comes to differentiating between is something community property or separate property. The date of acquisition a lot of times is something that can't be proven. And the only reason is because documentation that might prove the existence of, prove the date rather, documentation that might prove the date of acquisition either doesn't exist at all, like it was never created, or it has been lost in some way, or nobody knows where it is, or it's been destroyed or something. So documentation to definitively prove yes, this was acquired during the marriage, or no, this was not acquired during the marriage, I had it from before. Documentation to prove the precise date of acquisition a lot of times actually can't be found, or it's been destroyed, or it never existed. For certain things like houses, let's say, to kind of go back to my earlier example, for houses, obviously there's going to be deed paperwork, mortgage paperwork, title company paperwork and stuff. Hopefully, you have some of that still, if this is your situation, but if you don't, you can go to the mortgage company, you can go to the county or something to get replacement paperwork. A lot of times, if you don't have paperwork at all, it's, that's pretty easy, I guess. But if you do have paperwork but you've lost it, it's not always obvious where to go get replacement paperwork either. So just the reality is a lot of times you have a situation where the precise date of acquisition can't be proven. Inevitably, there's going to be one spouse who thinks that they had it from before, like they have this item from before, whereas the other spouse thinks, no, you didn't have this from before. We bought this while we were together. I own half of that. You need to split that with me. So proving the precise date of acquisition a lot of times can be really complicated because there just is not good proof one way or the other. So number three. So number three basically is going to be, let's try that again. Commingling is what I meant to say. Commingling of funds or of assets. Here's what I mean. For whatever reason, I actually encounter this a lot when it comes to inheritances. So I know earlier I mentioned basically, the definition of, separate versus community property. One exception to the general rule that whatever you acquire during the marriage here, that stuff that you acquire is going to be a community. One exception to that is stuff that you receive via inheritance. So I'll give you an example. So let's say that you get married, and during the marriage you have a rich uncle or a rich aunt, or your parents pass away or something, and in their will or in their trust or something, they leave you a huge amount of money. Let's say $10 million. Now, if you have $10 million, even though you receive it even if you receive that rather during the marriage, that's an inheritance. By statute in California, that is separate property. So if you do get divorced, do you have to split that? No, because again, it is separate property. It's one of the exceptions to the general rule that community property is whatever you receive or acquire during your marriage. Here's the problem that commingling poses. So let's say, for instance, that you do receive a very large inheritance, $10 million in the example that I'm using. It's very important what you do with that $10 million and what you don't do. And unfortunately, I guess $10 million might be kind of an extreme example, but let's just say $100,000, for example, also. $100,000 that you receive during the marriage because of an inheritance of some kind. A lot of times people will go, oh, hey, I want to save that money for a rainy day. Great. What they then do is then they put it into their savings account because in their mind, that's actually what makes sense. Money that you have that you don't need, that you're putting away, it has to go into a savings account. That's what we're all taught. The problem is that if you put that $100,000, which is again separate property, you mix that, for instance, like you put that into a savings account that has money in it already, and specifically, let's say that you put that $100,000 into a savings account that has community money in it. So you have $100,000 of separate property money over here you received by inheritance. You put it into a bank account that has $100,000, let's say, of community property in it. Now you've mixed it all together. So you have you have one account rather, one savings account that has community property money and separate property money. It's all mixed together. How do you unmix it to basically divide it in the event of a divorce? Sometimes you can't. And there's a case in California which, I swear to God, this is the actual name of the case. It's called Marriage of Mix, which I'll write over here and also link down below for you. But there's a case called Marriage of Mix that basically says that if you have commingled funds, separate property and community property money mixed together, for example, and it is not possible to unmix it, the presumption is that it is all community. So in other words, what often happens is you have separate property money, an inheritance, let's say. You put it into a savings account because you want to hold on to it, and you put it into a savings account that has community property money in it already. Time passes, all the money mixes together, withdrawals are made, etc. Now, when a divorce happens, you have to try and basically unmix it somehow. And let's just say you can't. Most of the time, you actually can't. That $100,000 separate property inheritance now is community, and you have to split it. So hopefully all that made sense. The basic idea is that if you don't guard your inheritance properly, like you don't segregate it properly, does it transform from separate property to community property? Technically not. However, it is something where you do end up having to split a lot of times. You do have to basically divide your separate property money with your spouse just because you commingled it earlier. So hopefully that made sense. The basic takeaway from that point is if you have separate property money and you have community property money, for the love of God, do not commingle the two. Keep it separate. It seems a little weird to have to do this, but if you want to keep it separate, you want to keep it segregated, how do you do that? It's actually really easy. You have one checking account that has separate property money in it. Nothing else except separate property money in it. It's 100% separate. You have another checking account that is 100% community. No separate property money over here, no community property money over here. 100% separate, 100% community. So you have to have two sets of accounts, basically. I've used a checking account in my example here, but you can apply that same idea to a savings account, money market account, CD, etc. Like you can apply it basically to a whole bunch of different accounts. But the basic idea is you have to keep it segregated, otherwise you might lose the separate property nature of it, and you might end up having to split it with your spouse in the event of a divorce. So commingling is bad. Segregation of money is actually good. So the last point is going to be date of separation. So I think that's number 4, if I'm on that now, number 4. So date of separation is this. Community property rights, again, are during that time period from the very beginning. Stuff that is during the marriage, stuff that's before, stuff that's after. So the marriage, the dates, I guess, that basically bookend the period of marriage. The date of marriage is when community property rights start. The date of marriage, actually, most people, to be honest, don't really disagree about that. It's not technically the date that you actually have the church ceremony. It's the date that the marriage, the marriage paperwork, I guess, all the civil forms that you have to fill out and file and all that stuff. That's the date where all those forms are filled out. So the date of marriage, like I said, most people don't really argue about that too much. The date of separation, however, sometimes people can. So the date of separation is when the community property rights end in the marriage. Date of marriage is when they begin. Date of separation is when they end. Date of separation in California, unfortunately, has a very vague definition of it for it. In its California Family Code section 70, which I will write over here as well as link down below. Date of separation in California is defined as the date that a complete and final break in the marital relationship has occurred. What the hell does that mean? I have no idea. It depends on each situation. The code section 70, goes over a little bit of guidance, I guess. It provides some guidance. Date of separation can be evidenced by both of the following. Number 1, the spouse has expressed to the other spouse his or her intent to end the marriage. So expression of the intent to end the marriage, that's one criteria to show what a complete and final break is. Criteria number 2 is conduct of the spouse that is consistent with his or her intent to end the marriage. So I guess to recap, date of separation is when a complete and final break occurs, and that's evidenced by one spouse's intent, vocalized or expressed intent to end the marriage, as well as that spouse's conduct, consistent with that intent to end the marriage. As you could probably guess, that is subject to a lot of interpretation. So let's just leave it at that, I guess. Basically, date of separation in California is something that, unless the parties agree on, they can actually fight for quite a while. So I guess Family Code section 70 also, this is subsection B if I recall correctly, says that the date of separation, when the court's trying to determine that, they can examine any relevant evidence. They can take all relevant evidence rather into consideration when determining when the date of separation occurs. So I think hopefully you can see what the intent of the date of separation is, but unfortunately there is no kind of bright line criteria that you can look at to say, yes, we've separated and it was on this date. California, unfortunately, does not define date of separation that way. It is something that's very amorphous, and the parties can, if they want to, argue about it for quite a while. So hopefully all of that made sense. Again, I'm going to try to really quickly summarize here. So when you're talking about applying community property law in the real world, some problems that you run into. Number 1 is the existence of a hybrid asset partially community, partially separate. A single asset can be both. And obviously the divisible part is only the community property part. So hybrid assets, that's number one. Number two is that it's not always easy to prove the date of acquisition for a particular item. Could be because there was no documentation at all and there really is no way to prove it, or there is documentation to prove it or other evidence to prove it, but it's been lost, nobody knows where it is. If it has been lost, maybe you can get replacement copies, maybe not. So proving the date of acquisition is actually going to be really complicated in certain situations. Sometimes it's pretty clear cut, sometimes not. Number three is that segregation of separate property funds and community property funds a lot of times will make it so the separate property funds have to get split in a divorce anyway. Just remember, commingling is bad. Segregation of funds, particularly because money is fungible, segregation of funds is good, basically. And the last thing, number four, is going to be that the date of separation in California, it's really important because that's when community property rights end. But unfortunately, California doesn't really have a clear-cut definition of what date of separation means. It's whenever one party believes that the marriage has suffered a complete and final break. The other party might disagree, for example, and you guys are off to the races and the court has to make a determination. So hopefully all of that made sense. This is not a comprehensive list by any means. There are a variety of problems that occur when you're trying to apply community property in the real world. This is just a partial list of the ones that I encounter most often. So hopefully all that helped. Go ahead and rewatch this video if you want. Share, comment, like, subscribe, all that stuff. And I will talk to you guys next time. Thanks.